Good evening and welcome to the Florida Cannabis Action Network special edition of Elevated Intel. My name is Jodi James. I'm the president of the Florida Cannabis Action Network. And with me tonight on this special edition is Steve. You've met Steve many a time. He's the guy in the background who is communicating with you if you watch our regular edition. Steve comes to us from Jacksonville. Welcome, Steve.
Hi,
And
Jody.
our It's really great to have you this evening. Steve stays behind the camera, but has done a great job of impacting our media outreach and our ability to get some video rolling. And so he brings a world of talent from as a retired military man. And we're really glad to have you. Thanks, Steve.
Thanks, Jody. I'm so glad to be here.
My pleasure. Yeah, me too. We're lucky that we get to do this and have some fun things to talk about. So, also with me this evening is Benny Blanchard. Benny is the chair of Florida Cannabis Action Network's third branch committee. And I want to tell you a little bit about the third branch. And then I'm probably going to tell you a little bit about how I met Benny. And then we're going to turn it over to Vinny because we started laughing when we were coming on about the kilt, and so I feel the story needs to be relived at least one more
Yes.
time before we put it to bed. So, for those of you who are tuning in because you've been following Florida Cannabis Action Network, thanks for being here. I'm going to go back and do a little bit of a civics lesson before we turn things over. And for those of you who've been watching and really paying attention, and this is your whole thing, stick around because there's going to be some amazing information. We're going to start with Civics 101. We're going to quickly move into Civics 201, and then we're going to spend the majority of our evening in personal liberty is for everyone. Did you like that? 101, 201 for everyone. All right, I made that up on the spot. We're rocking it tonight. So, for those of you who are wondering what in the world is the third branch, back to your original civics lesson, there are three separate branches of government. There is the executive branch in Florida, that would be Governor DeSantis and his cabinet, the folks that make up the leadership, the executive branch. That's going to be the Attorney General of Florida. That's going to be the CFO of Florida. They've been in the news quite a bit lately. When you get to the executive branch of the United States, you have President Trump. We've all been listening to the Secretary of Defense and seeing Secretary, is it Hethstead on the news of late. If you're paying attention, that's the executive branch there. Florida Cannabis Action Network decided a long time ago that we were going to focus a lot of our resources on the legislative branch. In Florida, that's the 160 men and women that make up the Florida House of Representatives and the Florida Senate. And those folks work in your communities. They live around the corner from you, maybe, depending on your zip code. Their office may be a few minutes from where you work. So these people are really accessible. And then it in at the national level, we have Congress. So that's the 400 plus folks that represent us at the congressional level, and then every state has two U.S. senators. So that's the legislative branch. So when the executive branch and the legislative branch are doing their thing, everything works out great. People are having a great time. Um, Business is booming. People feel free. And then lo and behold, there is a conflict. And when there is a conflict, that's when we need the third branch of government. And these are supposed to be equal branches of government. And that third branch of government is the judiciary. So that's going to be your civil court, and it's going to be your criminal courts. All that is going to make it up to kind of help guarantee that citizens get their rights heard, that businesses are being fairly represented in contractual deals, and that laws are being applied justly. wherever that law may fall. So that's kind of Civics 101. But of late, and some of you who've been following Florida Cannabis Action Network knows that we were very active in the most recent gun case, Cooper versus Merrick, that asked whether or not someone who was lawfully using cannabis was able to exercise their Second Amendment right. This, of course, in Florida, we have a right to medical marijuana. So that's all fine and well. That's a great use of the court. But as individuals, we can also make use of the court. And I think that's kind of where Benny has really made his mark in this space, is in the ability of the individual to access the courts. Now, when I first met Benny, he was, I think the first time I really realized who Benny was, he was in the cafeteria on the lower level of the House of, or the Capitol, right? There's a cafeteria there. He was standing there probably at the tea machine or the soda machine getting ice and wearing a kilt. And I thought, oh my God, this is Benny Blanchard. So I've never asked him why the kilt or, but one of the things that we talk about up here in Tallahassee is you have to make an impression and you have to make it fast and find common ground. And so I suspect, Benny, that that kilt was really the way you were able to individualize yourself. And immediately somebody's, from the Scottish clan and wants to find out if you're wearing your bagpipes or your underwear or whatever. I don't know what we're supposed to be asking. And Cynthia's not here. She would know. Cynthia's not here. But she's okay. So for those of you who watch for Cynthia, she will be back at 4:20 on Friday. But with me this evening, I have two lovely gentlemen. So I think one of the first things that we need to know, and so the audience knows what the format is going to be like. Benny's got some stuff prepared for us. Steve and I are going to be monitoring Facebook. And Steve and I are also going to be asking our own questions. So when I asked Benny to serve as our chair, we had been working up here, and Benny was telling me about the work that he was doing as a pro se litigant. So the first time was in a kilt. The time that really mattered, he was telling me, and it was a crowded room, and Benny and I were just talking, Benny and I, and he was explaining this to me. And I remember thinking, when they make the movie about Benny, all this stuff that I have done in my career is going to be like a little bit part in the movie entitled The Last Free Man. So I'm going to go ahead and tee Benny up. So, Benny, I think we were going to talk about what's been happening at the Supreme Court. And I think that kind of cannabis or civics 201 might be, why is the Supreme Court important, and really what are our courts supposed to do? And Steve, you're going to chime in. Steve and I are going to go off camera so that Benny can have some more presenting. And Benny,
Absolutely.
when we're going to raise our hand when we have a question and you're going to call on us. Steve, don't be shy.
Yes.
Absolutely, I won't.
Excellent. Because we want to make sure that someone who isn't a lawyer, and just as a disclaimer, this is not meant to be legal advice. This is
Absolutely.
a discourse
For
on
between
which
to explore legal language and better understand the things that protect us.
it's exactly right. So
Absolutely.
but we want to make sure that everybody realizes we're not lawyers. We don't play one on TV, but a free man or woman has a right to, has many rights, and how we exercise them is part of what Florida Cannabis Action Network would like to give to all of you, is the gift of understanding what your rights are, how you can exercise them, and someone to talk to when you're ready to take that step. So, Benny, I am interested, and I'm going to go off camera. Steve, we'll see you in a few minutes. I'm anxious to get into this.
Absolutely.
Much. So, Jody, thank you so much for the wonderful introduction. I started 8 years ago going to the Capitol to help lobby for hemp with Bob Clayton. And that is when I met Florida Cannabis Activist Network, Action Network as a whole. Since then, I've gone from being a real estate agent to studying a tremendous amount about the history of law, why we have the rules that we have, why do we have the regulations that we have, why do we have trouble using verbiage that describes the difference between hemp or marijuana, and why we use that verbiage. So the first thing that I'm going to talk about today is the Supreme Court. Now, the Supreme Court of the United States is the final arbiter of how the law is read, but they don't necessarily pick apart the very statutes. They also decide how the courts are to review these laws and what standards to apply. Now, everybody just recently had our gun laws repealed and changed here in Florida a few days ago. And that was because of a Supreme Court ruling called New York State Rifle and Pistol Association versus Bruin. Now, this ruling took apart the Second Amendment right and then the privilege or the regulatory scheme that went with it. So, because we have the right to bear arms and protect ourselves, including in the public sphere, there is only certain times they can regulate it. And one of the things they did was use a historical review point. Now, I'm going to put this up on the screen here just for a second so I can show you guys. Now, this is from the case, uh, New York State Rifle Association. You can go to the Supreme Court and find all of these cases in the opinions. They're there for you to read. And in those opinions, they will actually give you a little summary of what those opinions are. And so from there, you can start researching and learning different things. The Supreme Court said historical analysis can sometimes be difficult and nuanced, but reliance on history to inform the meaning of constitutional texts is more legitimate and more admirable than asking judges to make difficult and empirical judgments about the costs and benefits of firearm restrictions, especially given their lack of expertise in the field. From what this you can take away that the Supreme Court is now asking the lower courts to look at any regulatory scheme from a historical standpoint. While judicial deference to legislature is balancing is understandable and elsewhere appropriate, it is not deference that the Constitution demands here. The Second Amendment is the very product of an interest balancing by the people, and it surely elevates above all other interests the right of law-abiding citizens to use arms. Because of this ruling, we had the second DCA out of Orlando, our district court, made the ruling that we can now carry our firearms openly. This is what happens when the Supreme Court makes a ruling and then the state courts begin to apply it. So we see these major opinions that come out start to have a trickle-down effect. So what the court said was, the test that the court set forth in Heller applies today requires courts to assess whether modern firearm regulations are consistent with the Second Amendment's text and historical understanding. Of course, the regulatory challenges posed by firearms today are not always the same as the ones that preoccupied the founders in 1791 or the Reconstruction generation in 1868. So I want to take this and apply it to cannabis. And how is cannabis reviewed under the historical intent of a regulatory scheme? So I can use and quote Bruin and ask a judge in a declaratory judgment or in a case to construe what is the literal meaning of a regulatory scheme. So there are many, many different types of Supreme Court cases. There are about habeas corpus, which is your get out of jail free card. There is taxes. There is takings clause. There are First Amendment rights. There's the homeless issue from the grants pass. So all of these rulings tell the lower courts, the appellate courts, and the district courts how how you're to read that. So from there, I want to look at the next thing, which defines how the courts are to read statutes. And this goes all the way back to 1893. In this, an action was brought February 4th in 1887. Go ahead, Steve. An action was brought.
Sorry, it took me a second there to get myself off camera or on camera. So now I have a question, and this is just me being your average Joe. I'm not really familiar. What does something that happened in 1893 have to do with today, right now? Why is that
Well,
important for us?
and is it still case law? That was my question. So I'm glad you stopped him too, because I was just being slower. So is this still the law?
Yes, it is still valid case law today because it tells the courts how they are to look at items being brought into commerce, for lack of a better word, for the Commerce Clause. So when we first defined our taxation schemes,
Wait a minute. So what Steve said, that what happened in 1833, this is still the law today.
yes, this is still used today.
Thanks.
Got
So
it. Thank you, Benny.
what I'm going to do here is I'm going to read this in terms of what the subject is, tomatoes. But then I'm going to shift this verbally into viewing it from the cannabis standpoint. Okay? So this is going to explain what the case is and then what happened. It was an action in the court in 1887 against the collector of the Port of New York to recover back duties paid under protest on tomatoes imported by the plaintiff from the West Indies, which the collector assessed under Schedule G, provisions of the Tariff Act of March 3rd, 1883. Now keep this verbiage in mind here, especially provisions of the Tariff Act. Now, that act imposed a duty on vegetables in their natural state on salt or brine, not enumerated or provided for this act in 10% ad valorem. Ad valorem means the value of. So whatever somebody is going to pick it up off the street, the average value is going to be XYZ. What the plaintiffs did, which was the people who brought the lawsuit, they said that tomatoes wasn't a vegetable. Tomatoes came within the clause in the free list of the same act. Fruits, green, ripe, dried, not specifically enumerated for in the act. The reason being, to summarize it, was that the fruits had seeds and the vegetables didn't. Go ahead, Steve.
All right. So now here's my massive question as the average Joe, right? This says fruits and vegetables, and we're talking about cannabis. So how does that specifically apply here?
That's a great question. So we're going to go back and change what this reads to back duties under protest on cannabis imported by the plaintiff from the West Indies under the provisions of the Marijuana Tax Act. So can everybody imagine that mental shift? Then where
I
are
get it. So because it applies to that tariff act, it also applies to the Cannabis Tax Act because they fall under the same category. Is that what you're saying there?
think of it as a synonym instead of the tomatoes and the Tax Act of March 3rd, we're talking cannabis and the Marijuana Act. So that's the regulatory scheme.
Got it. Okay.
So they tax the regulatory scheme. What we're arguing here is this marijuana because it has above 0.3% THC, or is it hemp, fruits, green, ripe, or dried because it's less than 0.03% THC? That is when it goes into a regulatory scheme and how it is taxed because of the use.
That's like a massive light bulb going off there, Benny, and I appreciate you saying it like that. Because when you put it in a light like that, where hemp is legal, it's under 0.3% THC. Now I can make that connection, and I appreciate that.
Right. So we're still arguing over cannabis, but I want to point something out. What's not said in this? What if he wasn't bringing it in to import it for sale? What does that make it? Is it taxable? That's where the question is. Are we taxing ownership? I own tomatoes to feed myself and I brought them with me. Or are we taxing the intent to sell? And that's what the tax of the value is. So that is how I try to tell people, this is where we have the trap. Are they, go ahead, Jodi. Are they holding us, are they criminalizing our ownership of cannabis, or are they criminalizing the possession?
So, under the Marijuana Tax Act, which was the first, that was the first time that we taxed cannabis cultivation, right? The Marijuana Tax Act, is that accurate?
That was
Okay.
one of the first really big ones.
Well, that's kind of the one that I always learned that that was kind of the turning point in marijuana prohibition because they made the tax on the marijuana so high that the average farmer wouldn't be interested in growing it. And so they basically regulated us out of our ability to grow a crop. And
Correct. The
there were,
value of the tax was exorbitant. But we were also not arrested for owning it at that time either.
correct, correct. And possession was 100% legal. But if you were selling it, the tax, they just taxed you out of it, right?
Well,
So,
I'm gonna call out what you said in a good way. You just said possession was 100% is legal. It's 100% regulated. When you possess property and with intent to sell, that is when you have to have the license. That is because you possess it as an artificial persona.
my
When you
business,
property, I have no intent of doing anything except eating and drinking with it.
right?
So that's not a taxable event.
Well, I was going to say, coming back from Europe, they didn't even in tariffs, but you said something about, and let's go back. It Vegetables have seeds, right? I mean, a pepper, what vegetable doesn't have seeds?
Vegetables do not.
So is a pepper a seed,
A
or
pepper
is a pepper as a fruit?
or
Fruit,
common verbiage and language because we use it for cooking and food.
but it has seeds.
Correct, botanically. So let's go back to this opinion for
All
just
right.
now.
Okay. This
And
is
they actually
challenging
discuss
stuff,
it.
guys. So thanks for sticking with us.
Now, does not
We
classify all things there. That does not take all kinds of fruits and vegetables. It takes a portion of them. I think the words fruit and vegetable have the same meaning in trade today. I understand the term fruit is applied to only plants or parts of plants that contain the seeds. There are more vegetables than those in those enumeration given in Webster's dictionary under the term vegetable as cabbage, cauliflower, turnips, potatoes, peas, beans, and the like. The other witness testified, I don't think the term fruit or the term vegetables had in March 19 and prior thereto any special meaning. The counsel then read in evidence the same dictionary definitions of the word tomato. Then read evidence pea, egg, plant, cucumber, squash, and pepper. Then read in evidence from Webster and Worcester's dictionaries the definitions of potato, turnip, parsnip, cauliflower. No evidence so basically they were saying the single question in this case, whether tomatoes considered as provisions are to be classified as vegetables versus fruit within the meaning of the Tariff Act. There is no evidence that the words fruit and vegetables have acquired any special meaning in trade or commerce. They must receive their ordinary meaning. Of that meaning, the court is bound to take judicial notice. So basically, this is saying, botanically speaking, tomatoes are fruit of the vine, just as cucumbers, squashes, beans, and peas. But in the common language of the people, whether sellers or consumers of provisions, all of these are vegetables which are grown in kitchen gardens and which are either eaten cooked or raw, or like potatoes, carrots, parsnips, or beans, usually served in dinner, and not in, like fruits, generally as in dessert. Does that make sense, Jodi?
I wouldn't want to go that far. Um, I did like the fact that the Supreme Court in 1980 or in 1893 was talking about fruits and vegetables. But I do think it's interesting, and I want to get into these new decisions. So in 1893, the court decided that there was a difference between a provision, something that someone was bringing in to satisfy themselves.
To use it as how the tax applies. That
All
is
in how I'm going to use it.
general gist in the opinion.
Okay. So how I intend to use something is foundational in the way that the court is going to look at what I'm doing.
Correct.
Okay. All right. So so what should the court be doing? So we've seen what the court did in 1883. And you're believing that there are some cases that have been solved pretty recently that go to my
Yes.
ability to cultivate for myself on my own property, to cultivate it as my property. Is that an accurate to
Proper,
cultivate it as my property?
privilege to cultivate.
Privilege to cultivate. So, I like a privilege.
Absolutely
Um,
love a privilege.
Privilege is taxable.
oh wait, I want a right then. Can I get a right? Can I have a right, please? Because I think a right is not taxable. Um,
For happiness. And we're actually, this is a good time to bring up
give me a
one
right. Give me a sorry.
to reflect that. Let me pull this grade up. This is one of my favorite old cases, and it's what's called a dissident. Was about beer brewing, and this is this case is still cited to this day in terms of regulating beer, wine, or anything that could be dangerous to society. Mugler had built an entire brewery, and then 1 week later, the legislature made it illegal to the defendant was indicted for manufacturing beer without having a license to manufacture for medical, scientific, and mechanical purposes. You also find this verbiage in property taxes. There was no allegation in the indictment or no proof or attempt to prove that the beer was manufactured for sale or barter. So this green section is what's important for you. The right to manufacture for his own use, either food or drink, is certainly an absolute natural right reserved to every citizen, one guaranteed by the 14th Amendment, and when under the laws of Kansas he is punished for manufacturing beer, it abridges his privileges as a United citizen of the United States and deprives him of liberty and property without due process of the law. If the Constitution and prohibitory statute of Kansas leave any resident of natural liberty, it will require microscopical inquiry to find it. If a state convention or legislature can punish a citizen for manufacturing beer or wine or bread, not to be sold or bartered or even given away, but for his own use, then instead of civil liberty, we are living under the most unlimited and brutal despotism known in history. So this is kind of sort of what's happened now. So I'm going to bring you over to why I try to define ownership and use so much. If we are right in the assumption that the citizen stands before the law in a dual character, both as an individual and a member of society, that in the former status he has certain natural rights not surrendered to society but reserved to himself in necessary pursuit of happiness, that his right to manufacture any article of food or drink or apparel, provided the process of manufacturing does not engage in the lives or property of others, is one of those reserved or natural rights. So that is why I keep saying we have the natural right to grow food for our own consumption. But the way laws phrase it today, it is illegal to cultivate because cultivation is a privilege under a regulatory scheme.
That makes a lot of sense. When you put it in those terms and you compare cannabis slash hemp to the brewing of your own alcohol, it makes perfect sense. I have my own house that I own, and I'm not distributing the stuff. I'm not trying to make money off of anything. I just want to grow stuff for my own use because right now I am a medical user for pain, and I am currently smoking on average between a half ounce to 3/4 ounces a week. And for those of you who don't have a card and don't participate in the regulatory scheme, as Benny would put it there, that amounts to about $600 a month. And I'm not even using what the doctor is telling me that I should use. I'm using less than what the doctor is prescribing. But the government is stepping in and saying, no, you can't do this because we want to make sure that you're getting your tax in there. And I understand them wanting to get their tax. That's perfectly fine. Everybody wants their taxes. Totally cool. I get it. I'm not saying don't tax it. But if I'm not selling it and I'm just doing it for myself, like my cousin who lives in South Carolina, he's a pharmacist, but he loves brewing his own beer. He doesn't sell it. He just brews it for himself, keeps it in a kegerator in his garage. When it runs out, he brews a new batch. It's awesome. Like, why can't I do the same? Why do I have to pay $600 a month?
We have not
So,
argued within the regulatory scheme correctly. Go ahead.
Oh, sorry.
so there was a time where, under Prohibition, it was legal for me to possess alcohol for myself. My mom told me in one of the houses that they lived in, my grandpa and his brother had a still, and these are religious folks. So I don't know how much they would have been selling, maybe, but likely they were brewing something for their own use, maybe even sacramental use for that matter, or medicine. That would have been legal under alcohol prohibition. Have I ever lost the ability to, under this decision, because I love Kansas, I understand why you cite it all the time, because under Kansas, it looks to me like I should be able to uh grow my vegetables and eat my fruits, and I should be able to uh, celebrate the fruit of my labor, right? So
Well,
that
I-
or what?
Absolutely,
with,
Jody.
with their statute for growing vegetables and foods, nobody's brought it before the court to argue, does this include cannabis outside of the regulatory scheme?
All right, carry on, Benny. Let's hear more.
So because so let's go and talk about the regulatory scheme itself. Let me pull this up, folks. So this is something called this is one of the more recent cases that was decided in the October term 2018. It's Nick versus Township of Scott, Pennsylvania. The Township of Scott passed an ordinance requiring that all cemeteries be kept open and accessible to the general public during daylight hours. Petitioner Rosemary Nick, whose 90-acre rural property had a small family graveyard, was notified that she was violating the ordinance. Nick sought declaratory and injunctive relief in state court on the grounds that the ordinance affected the taking of her property, but she did not bring in an inverse condemnation act under state law seeking compensation. So it all just down to saying that the government violates the takings clause when it takes property without compensation, and a property owner may bring a Fifth Amendment claims under 1983 at any time. Why isn't my cannabis property? Why can't I bring a 1983 claim at the same time? Nobody's really argued that cannabis is property. However, everybody fights over the fact that we are within a regulatory scheme. So, Steve, you have your card, for example. That places you within the regulatory scheme, and the state has the right to regulate you. You chose to use the licensed scheme. A person who doesn't, inversely, actually has the ability to grow their own medication. But the state is stopping that because in the guise of, well, we have the right to regulate you in terms of the in terms of the Commerce Clause. There's one case that I don't have here, but everybody may remember, called the Obamacare case, where the Supreme Court said, we can't force you into paying the Obamacare tax because of mere inactivity with property or self. In essence, you cannot be compelled into a taxation scheme. It's the same thing here. How did we get compelled into the regulatory scheme of what I own is hemp or what I own is marijuana when it's actually just cannabis?
Right. So here is the big thing, and I love that you explained it in those ways. Um, I'm sorry, I had a massive brain fart there. That's why I was stalling. For those of you that don't know me or my history, I have a spine issue, and I am very heavily medicated tonight. And every time I go off camera or you see me twitching, it's because my back muscles are actually spasming. Um, and it made me lose my complete train of thought while I was mid-sentence. So I'm going to lower my hand and I'm going to let you continue, please.
So what happened was, go ahead, Jody.
So while Steve's figuring it out, let's talk about the what you mean by 1983. So that's a term of art that not everybody understands, and even I thought it was something different the first time you and I talked about it.
By
Now,
oh, you mean
I, and
1983 suit?
yeah, the 1983. So I wanted to explain that. And this lady, the Mary Rose Nick, would her case have been decided differently if she had charged the city with it, it says inverse, she did not bring an inverse condemnation action. So if I were going to want to um challenge this, am I going to have to do actions in more than one court? I guess would be two questions. So what's 1983 mean? Um, and how does this impact what I'm going to have to do if I believe that cannabis is something that I should be able to um, cultivate for myself on my own private property?
Well, if we take this case, this opinion, and again, we file off the serial number and we start replacing keywords with cannabis. The town of Zephyr Hills, Florida passed an ordinance requiring that all cannabis growers be required to get a license to grow either hemp or marijuana. That would essentially create a takings. Does that make sense, Jodi? So the takings of property, it doesn't matter what property is. Property can be a home, it can be a savings account. All of these things, whatever you own, it is property. There's a great case called Lynch versus Household Court that you can look up, and it talks about this in context of a 1983 lawsuit. A 1983 lawsuit arose from the Ku Klux Klan Act, whereby in the Reconstruction era, where the state would take black people, make them apprentices, which was basically a slave as another name. So they passed the 1983 statute to guarantee you the ability to sue a state actor in federal court to protect your rights. Because states can sideswipe your rights and hide them within the state court and ignore it. But the federal court brings this back out into the open. So that's what this case is doing. This case is saying I don't have to argue what could be a crime in the state court.
Got it. That makes sense there. And,
Right.
I'm really starting to figure out why lawyers have to go through so much extra schooling just to be a lawyer, because a lot of this is very confusing.
Yes, it is. And legal speak, we speak in a dead language for a reason. It doesn't change. What happens is we change the interpretation of that dead language and the way we construe laws. The Supreme Court got rid of the Chevron deference, which means that we no longer defer to the agency's interpretation of a law. So for cannabis, the agency's interpretation of what it is as a drug, it's now just that, an agency interpretation, because it has not been codified into positive law. That
And that right there is the literal key to everything. I'm sorry, I didn't mean to talk over you. I just had that light bulb moment right then and there. Woo, that is powerful, Benny, what you just said.
so because if we no longer have to wait until we're injured at the state level, any type of takings claim is up for grabs. We just have to switch the verbiage to see, well, why did you presume I was trafficking? What made you believe I was in the regulatory scheme of driving? Or I needed a concealed weapon, a police officer.
So going back to the beginning, it's you can see a clear line between the New York Brewing case, where they changed gun laws and said that we have to look at historical use. You can track what we did in our open carry law to that decision. And that Supreme Court decision, along with this Supreme Court decision about regulatory scheme, if I'm understanding correctly, lead you to believe that we're asking the wrong question, and that the question that we should be asking is why did you take away, why did you take a taking? Why did you take my right to
Why did you infringe
plants?
on my right to grow?
Why did you infringe on my right
Yeah,
by putting cannabis into a regulatory scheme? Now, they would always have said, well, cannabis is just too dangerous for you to have in a civil society. And I've heard this. In a civil society, we give up certain individual freedoms in order to build bridges. Seriously, that you can find it on YouTube. That's
Absolutely.
that's really what they said to me, and I don't. So how do we answer that? Did I give it up, or did they take it?
they took it away. They took it away. That's the whole point we have to argue. Just like land is taken, so can a car be taken. So can my shirt. So can something. Oh, your money. Money is a fantastic confiscation subject. Where did they get the right to take that property? How
Right.
I mean it was used within a regulatory scheme to grant them the ability to say this was publicly used. We now get to take it.
Right. Exactly. And I know that I personally don't understand a lot of the law stuff. I understand a little bit, thankfully, because I took a couple classes in college, so it really helps me wrap around. But, most people didn't. And and hearing you talk about it in this way really helps to show like, hey, they are infringing on our rights. And I'll tell you what, I know a lot of people feel this way. A lot of us, we don't really care about Democrat, Republican, any of that politics stuff. But one thing that I personally care about a lot, especially as someone who spent 21 years away from my family constantly, and my wife too, because she was also active duty. So when I was home, she was gone. When she was gone, or when she was home, I was gone. Um, the one thing I can't stand is seeing the government that I stood up for and protect so long to say, oh, but wait, now you can't, now thank you for your service, but you can't grow your own vegetables anymore. Sorry. And that gets me so passionate.
Well, and maybe we had the wrong discussion with cannabis all along. Instead of talking about it as a medicine or talking about it as a commodity, maybe we should have talked about it all along as a vegetable. So I
Absolutely.
know we got
It
into that a little bit, but it might
was
have been a little late.
all the time. Wickard versus Filliburn, which was the wheat case where they said the farmer could not grow excess wheat. But what people don't realize is that case said the government has the right to regulate anybody it subsidized. It
Mm.
subsidized Wickard as a taxpayer to specifically grow that wheat. So he then fell within the regulatory scheme. We look at the other case, Gonzalez versus Raich. These are medical marijuana license holders. They
Right.
fall within the regulatory scheme. So, because we're subsidizing your medicine by the government, we have to have a license. We can't grow unless they give us that permission.
Oh
It's
yeah, everybody wants to have you in a database these days. It's all about taking that data now.
not about the
So,
data, it was about the taxation.
Yeah, you are correct on that too.
so fascinating. I wasn't a huge fan of the 2014 and 2016 medical marijuana ballot initiatives, codifying some of this stuff in the uh, Constitution was problematic for me. Is it possible, one of the things that they say in the clause in the constitutional amendment is that if something is found null and void by the court, the rest of it is upheld. So,
Well, the
is it
entire
possible,
state held. It just
pardon?
applied to us because it's a regulatory scheme. It's an as-applied challenge. How did I fall within the regulatory scheme? How did you determine I was owning it or using it?
Well, I think I chose to be part of the regulatory scheme, but why they felt the need to have a regulatory scheme around my medicine might be a question too. So, part of what the third branch does with Florida Cannabis Action Network, for those of you who have stuck with it this long, is we spend a lot of time discussing how a person can exercise their rights. If you were reading the comments like I have, you will find that my dear co-host Cynthia Brewer, who's not with us tonight, says that exercising her rights is the only exercising she does. So, but
I don't believe that, Cynthia. You're too
I
fit.
don't believe it. She's
Mm-mm.
beautiful.
Nope.
My beautiful co-host. But maybe she spends a whole lot of time picking up, what other people are putting down. I don't,
Who
we all
knows?
exercise in our own way. So, Benny, as we're thinking about wrapping up, we know that the Supreme Court has basically been in favor from the beginning of an individual having individual liberties, and that being able to care for themselves, including gardening and
General basic medicine for yourself.
generating it for yourself was something they approved. We know that Governor DeSantis here in Florida understands that we have a right to garden. How are we going to tie all this together? And what is it that the third branch, do you have plans for the third branch that you're ready to share at this point?
I'm drafted two things. I'm done with a declaratory judgment, that draft, to ask the Supreme Court to decide whether or not our right to grow was codified in the right to grow statutes, where it said that a county can't prohibit a resident from growing vegetables on their front lawn. And then it
Right.
specifically defined all of these things. Any fruit, flower, vegetable, plant, seed. Well, if we go back to Nick, that's the very description that we just went through here, the common. So why is cannabis on this list? If I want to sell it to the public, then I need my license. So
We
that
agree
it
with that.
identify where does the regulatory scheme come into play, and can you compel me into it?
Right. And other states have had this discussion. Like if you look at what Michigan has done in the past, I know, I'm sorry, I didn't bring this up. I kind of did this research at in the moment.
Good.
But Michigan allows an adult to grow their own cannabis, and they're actually allowed to give away an ounce to an adult that is over the age of 21 legally. And I think that that's awesome because, I grew up in an Italian household, and I remember my Aunt Loretta. I don't know if you're watching, Aunt Loretta. I kind of hope you are right now. But we all used to make cookies and ice cream, and she had this garden, and we would grow vegetables, and through the entire neighborhood, we would be trading vegetables and stuff, and nobody cared about taxes or anything like that. All we cared about was being good neighbors and having a good time and sharing the fruits of our labor, as Jodi said earlier.
Absolutely. So I think the difference between what Benny's talking about, Steve, is them, the legislature, creating a series of conditions that I have to follow before I can participate. And once they have created those conditions and I have agreed to those conditions, now I'm in the regulatory scheme.
Right.
Separate, and
But
I don't enter into any regulatory scheme to grow tomatoes in my backyard.
right. And I'll be honest with you, if I wasn't absolutely terrified of being arrested,
Me
I would
too.
have not chosen to be a part of this regulatory scheme. I would have chosen to grow my own as, human beings have been doing since the beginning of time.
And I think that's the crux of it. And that might have been the concern. Thanks for bringing that up, Steve. That might be where my concern is right now, is by becoming a patient, have I given away a right that I may want back really soon? So,
Absolutely. I definitely
uh,
want my rights.
so in a perfect world, I should be able to grow plants in my yard that have nothing to do with
You
the
wouldn't
government.
need to enter the regulatory scheme if you were able to grow.
Absolutely, I would not have. I don't need someone else to grow for me. Well, and I guess that's the crux, Benny. Maybe I would have because I've spent an awful lot of money on tomatoes for having grown, and I've spent an awful lot of money trying to grow tomatoes. So it may just be cheaper to buy a wild wonder. And so I think in a perfect world, I would want to have a hybrid opportunity. I would want to be able to exercise um my rights as a sovereign citizen. My inalienable right is what we've always talked about it as, an inalienable right uh to
You're
have access to this plant.
sovereign.
Absolutely. Because you know what? You've said this before, and I didn't think about it until I heard you say it. Just because you can, like, you have the right to grow doesn't mean you're going to be good at it. It's not easy. And there are going to be times when you're not going to have a nice grow and you're going to want some good quality flower, and you're going to want to go to the Flowery or Jungle Boys and purchase from them and support their amazing businesses, you know?
Sunnyside, Planet 13, we've got
Absolutely, them
some
too.
great dispensing organizations out there. True Leave, they're everywhere, and have some products that are certainly worth purchasing. Uh, so Benny, what if I want my cake and I want to eat it too? Because I think I mean, there's a part of me that wants to be part of a regulatory scheme so that I can go and buy cannabis from somebody who is licensed. What say you, Benny?
We'll get there. We'll get there. That would be the second declaratory judgment to break the
Huh?
vertical scheme. Because as I was saying a little earlier, you don't want to call yourself a sovereign citizen. That is a very bad trigger word in the courts.
Okay, they don't want me to be sovereign.
Well, it is now used in conjunction with a term called vexatious litigant. It means trouble.
Oh,
Well,
yeah, that sounds like me.
in the state of Florida, you want to call yourself a natural person. That is codified into our Constitution, that you have these rights, the right to happiness, to be rewarded for industry, to acquire, possess, and protect property. If you have all of these rights and you call yourself a natural person, you're not a taxpayer anymore. You're outside of the regulatory scheme. Now, this is just an educational opinion from having litigated in the courts. Until you understand these concepts, tread carefully, but study your Constitution. Your rights come from it. Then the statutes of the regulatory scheme will apply. That is how somebody's private property was taken by the county and placed into public use by saying you have a cemetery. So just because you grow cannabis doesn't mean your property is declared agricultural, taken into public use, and you are now growing marijuana or hemp. The same principle applies. That is why we need to look at the takings clause in a different fashion when it comes to private property differently.
That's
That's
an excellent wrap up, Benny.
how.
I totally totally get it. Thank you very much and he came in a couple minutes early. God bless you. Um, it was a fascinating hour with you today, Benny. Thank you very much for bringing that together.
You're welcome.
I feel like a natural person. I am a natural. No, no one is here to hear me sing natural woman, but it does inform the way that we act and the way that we behave. And I'm sure that there are people who are going to see this because, well, Steve, our producer, is going to make sure that there are people who see this. Uh,
Absolutely. I'm a
The
blasted all over the place.
Thank you. We'll have more questions about this. Um, Benny is available through Florida Cannabis Action Network. You can always send an email or phone call to Cannabis Action Network and we'll get you to Benny. We are happy to help facilitate that. Benny is always looking for people who understand some of these concepts and who are interested in becoming a member of Florida Cannabis Action Network. It's easy, just $5 a month as an individual, $25 a month or $250 a year as a business. And special folks are donating $500 a year for a gold membership, and we love them extra. No, we love everybody the same. It's not true. We love everybody the same. But we do appreciate everybody who gets together and works this Florida Cannabis Action Network. We're all volunteers coming from our heart to help to give you some information. If there is one last thought that you want people to know, Benny, I thought your wrap up was great. You know, we've got to really rethink the way we talk about these things. And we are taking donations as Florida Cannabis Action Network. If you'd like to earmark a donation to our pro se litigation, it still costs money, even if volunteers are doing it. And I think we have our first $1,000 donor that is going to be giving to that project, but it would be fabulous to have someone match that $1,000 because this is certainly important stuff. And with $2,000, we can do twice as much, right? Isn't that what they say? Steve,
Absolutely.
what would your final thought be tonight? Anything that you would want people to remember?
I think that I have proved that I have no more thoughts left for the night, more than I can count tonight. So I'm just gonna stop while I'm ahead. Because
Yeah.
my Navy buddies, if they're watching this, I'm telling you, I am gonna get destroyed tonight. I'm never gonna live this down.
Well, thank you very much for stepping outside your comfort zone. One of the girls said, Jodi, on your tombstone, it's going to say, Here lies Jodi James. She got us out of our comfort zone.
You sure
So,
did, Jody.
come be one of us. We really want the folks who see this to join us. It's easy, flcan.org. Follow Elevated Intel every Friday at 4:20 with myself, Jodi James, my co-host Cynthia Brewer, Steve from Jacksonville in the background, making sure that things work. And Benny, you can find Benny with Florida Cannabis Action Network and off doing things. Remember, the last free man in America. Benny Blanchard, thank you very much for joining us tonight. We're going to say goodnight.
Good night.
Thanks for watching.